Of course, some actions clearly violate the code of conduct, such as instances when a judge is caught taking a bribe. However, although judges have been caught accepting bribes, that rarely happens because they are usually not stupid enough to take money from someone who is not part of the crooked judges club. Also, if an attorney or a party is heard bragging about bribing a judge, that should be probable cause to start a criminal investigation of them as well as the judge. But as you can probably imagine, our system has become so corrupt that the authorities have failed to act on even that type of evidence, and have even failed to act on documentary evidence that I have submitted showing the commission of felonies by members of Florida's court system. Unfortunately, in the vast majority of cases, the parties involved in fixing a case will not be so stupid that they will openly brag about their ability to improperly influence a judge, or so stupid that they will leave evidence of the commission of criminal acts visible in the court file. In most cases, the only ways to determine whether judicial misconduct has occurred is by being present when the misconduct occurs, or by reviewing the case file and the transcripts of the proceedings to see whether the judge has ignored the law or the facts to the point that the judge's actions indicate a fundamental violation of due process or an abusive process. What is an abusive process? Black's Law Dictionary defines it as an improper and tortious use of a legitimately issued court process to obtain a result that is either unlawful or beyond the process's scope. However, if a court issues an order or enters a judgment against a person who is not a party to a lawsuit, and therefore a person who the court has no jurisdiction or power over, can you say that such order or judgment has been legitimately issued? Of course not. And if a court does so, it's a prime example of judicial misconduct. They have blatantly exceeded their jurisdiction. In fact, in Florida and many other states, if a judge issues a judgment or an order against a person who is not a party to an action, the judge is personally liable for the damages flowing from such order or judgment. But federal judges, on the other hand, are completely protected from liability for such outrageous actions by the federal doctrine of judicial immunity, which, of course, they created. The Restatement of Torts defines abusive process as use of a legal process against another primarily to accomplish a purpose for which it is not designed. For example, if a judge charges a person with indirect criminal contempt for filing a motion which is allowed by the rules of procedure and allowed by case law, rather than paying a judgment entered against this person, even though the person was not a party to the lawsuit, it would appear that such a judge was threatening to use his power. In most cases, we need to see whether the judge is acting in a manner which indicates that he is favoring one side by ignoring rules or controlling precedent, or is otherwise acting in a manner inconsistent with due process. To do so, he must review the applicable rules.
Judge appointed is married.
And that discipline disciplinary action is rarely taken in the few cases that are investigated. In Florida, you could report it to the Judicial Qualifications Commission, but those reports are kept secret unless the commission decides to file charges against a judge, which once again rarely happens. And when it does happen, quite often the commission is going after a judge who rocked the boat by exposing improper conduct by another judge. Yes, fortunately, there are judges who have integrity. You could also report judicial misconduct to law enforcement, like the FBI or the prosecuting attorney. But although action is occasionally taken by law enforcement against corrupt judges, it's rare. You could write your congressional representatives and senators, but Congress has rarely taken action to remove a federal judge. You could write your state legislators, but that also rarely results in any action being taken. You could tell the press that they almost never report on judicial misconduct unless it involves drunkenness or sexual misconduct, or unless too many people know about it for the press to ignore. You can tell your friends, your family, your co-workers, and those in your church, but you will probably find that many of them are scared to face the truth because they don't want to believe that it could happen to them. Of course, some will be supportive rather than running away. But what can they really do that can help? They can show up for hearings because judges feel, and I know this from personal experience, judges feel more uncomfortable ignoring the law and the facts when they're facing a crowd. Your supporters can attend a rally at the courthouse. That can really help because it may draw some media attention. But you have to keep it up. You have to keep it up. You have to keep it up. If you're doing one rally one afternoon and you tell every person in the local press, let me tell you, it'll be amazing if it makes the news or the paper. You have to keep it up. There's a woman in Naples, I practiced law in Naples for a while right after I got into college, that sat in front of the courthouse with signs about misconduct by a judge for a year before they finally started talking about it in the press. And they had to talk about it because everybody that went to court there saw her for a year. So finally, they started talking about it. And by the way, the judge is still on the bench. But at least the public knows. Okay, of course, if your state is one of those states that still allows you to present evidence to a grand jury, then you should put your evidence in. You can fight to restore your right to petition for a redress of grievances to a grand jury. Once again, if those judges know you can go into a grand jury and talk about what they did and the law they violated, they're going to quit their corrupt behavior so quick. It'll be amazing. It would transform the country overnight. That's why they took that right away from you, because they did not want the power in the hands of the people. You can also fight to restore your right to a jury trial in all cases, because far too many judges have proven that they are untrustworthy. You can fight to have more public oversight of the judiciary by requiring information on judges' homes and finances to be made public, and by requiring video cameras to be allowed in the courts. You can push to make complaints about judges' public record available for all to see on the internet, and to have those complaints reviewed either by a grand jury or at least by a committee that is not made up solely of judges and attorneys. You can take away the power of bar associations to take actions against attorneys without a jury trial.
Yes.
Right now, they take your license away, and it's like a joke because a corrupt judge sits over you. In my case, because they've been going after me for 4 years, I wasn't even allowed